Okay, I'm reacting to a video of a dog running down a driveway and knocking somebody over. Okay. Hi, I'm Blake Zaccagnino. I'm an attorney that works mostly on injury claims in New York State, and I wanted to talk to you today about the standard in domestic animal injury claims in New York State. And generally, I've seen these cases come about mostly after dog bites or other situations where an animal does something that then injures another person, whether it be jumping on them, biting them, growling at them, leaping on them, or tripping them, or doing something that causes them to have an injury. And in order to recover from a dog owner for the injuries caused by a dog in New York State, generally you have to prove that the dog owner had knowledge of the animal's vicious propensities. In other words, and just to really simplify that, they have to have actual knowledge or constructive knowledge that their animal had a tendency to act in a way that then caused an injury, in a way that resulted in the injury in that specific case. And I wanted to read to you some case law that better explains the standard and then gives some examples of proof that may satisfy that vicious propensity standard. So this is from a New York State case, and it says the owner of a domestic animal who either knows or should have known of the animal's vicious propensities will be held liable for the harm that the animal causes as a result of those propensities. Vicious propensities include the propensity to do any act that might endanger the safety of the person and property of others in a given situation. With respect to the liability of a domestic animal owner, such as a dog, knowledge of vicious propensities may, of course, be established by proof of prior acts of a similar kind of which the owner had notice. In addition, a triable issue of fact as to knowledge of a dog's vicious propensities might be raised, even in the absence of proof that the dog had actually bitten someone, by evidence that it had been known to growl, snap, or bare its teeth. Also potentially relevant is whether the owner chooses to restrain the dog and the manner in which the dog is restrained. The keeping of a dog as a guard dog may give rise to an inference that the owner had knowledge of the dog's vicious propensity. So basically, the owner has to know or have some reason to know that whatever animal caused the harm had a tendency or likelihood to cause that harm. So I hope that was a good explanation, and if you have any questions or want me to clear anything up, please leave it in the comments below. Thank you.